So you logged in now?
Yeah, we are good down here.
For mine, are the other people running this thing where it wants to do a Cisco WebEx add-on required?
I've got this.
Yes, and I'm using Chrome and it worked.
And I was using Chrome yesterday and it worked just fine. So did you have to do something?
Yep, you just let that thing download and make sure your pop-up block thing is off. It'll say always allow from this website. Make sure that button is checked. It's in the upper right-hand corner of your Chrome window. This is Ratna Gupta.
This is Karen Dunnigan. I'm the field solicitor in the Rocky Mountain region in Billings, Montana. And we understand there are maybe some technical difficulties today. So we will be presenting the slides on the WebEx, so we'll try to tell you when we're going to go to the next slide. So if you're following along in the portal, you can click your slides for yourselves. With me today are Anna Rowe, who is an attorney advisor in the Pacific Northwest region in Portland, and Kathy Fuchs, who is an HR specialist with the Office of Human Capital Management for BIA here in Billings, Montana. And we were brainstorming about topics we might present for EEO training that are outside the normal Title VII kinds of issues. And we had thought, because we work in the Department of the Interior, that Indian preference and national origin discrimination might be a good topic. And so I do hope you enjoy it. It was actually fun to put together, and I have worked in Indian issues and with BIA personnel issues for about 25 years, and of course, always just rely upon the big case Morton V Mancari, but hadn't really delved into a lot about Indian preference. So I learned a lot, and it was very interesting. So next slide, the agenda for today is we're going to talk about what is Indian preference. We're going to discuss the interplay of Indian preference with Title VII. We will talk about EEO issues that arise related to Native American employees and some examples of recent and pending EEO cases. And then since we're all scattered around, we will have questions at the end. We'll leave enough time for that. Kathy and I are going to cover the first two topics, and then Anna will take the next two topics. Next slide. So what is Indian preference? Section 12 of the Indian Reorganization Act of 1934, which is codified at 25 U.S.C. 472, accords qualified Indians a preference to vacancies in positions maintained by the Indian office. And as we go through this presentation, we're going to talk about each of those elements. That is, what is an Indian, what is a qualified Indian, what are vacancies, and what are positions maintained in the Indian office. The Supreme Court said in addressing this Indian preference statute that the purpose of the Indian Reorganization Act was to establish machinery whereby Indian tribes would be able to assume a greater degree of self-government, both politically and economically. And that purpose is going to be important as we move through this presentation, because it helps courts interpret what Indian preference is and how it should be applied. I was interested to learn that the federal policy of according a hiring preference to Indians in the Indian service dates back as far as 1834. 25 U.S.C. Section 45 talks about the appointment of interpreters or other persons employed for the benefit of Indians. The other statutes cited talk about preferences for herders, teamsters, laborers, clerical and mechanical help, and then matrons, farmers, and industrial teachers in Indian schools. Next slide.
Preference is given to persons of Indian descent who are members of any recognized Indian tribe now under federal jurisdiction, or descendants of members who were residing on an Indian reservation in 1934, and that descendants of members residing on reservation in 1934 is very rare anymore. If you do the math, that individual would have to be at least 80 years old. 1/2 or more Indian blood of indigenous tribes, and Eskimos and Native Alaskans.
Next slide.
The qualification standards that are used in hiring is that the agency may not blindly apply blanket qualification standards to applicants with Indian preference. Agency is required to do an individualized assessment of applicants to determine if their experience and background makes them qualified for the job with or without the necessary qualifications. And that necessary qualifications would be something like having to have a master's degree for a social service position or an actual bachelor's of science degree for an engineer, those types of necessary qualifications. But there is no absolute obligation to establish special standards if, after giving full weight to the unique experience and background of Indians, agency concludes that proper qualifications are those established by OPM. And in fact, the BIA used to use accepted service qualifications up until just about 2000. One of our staffing specialists thought maybe it was 2001, but I really couldn't put my hands on the policy. So that change hasn't been that long ago. And then the BIA policy is that Indian preference will be afforded to qualified Indians meeting the job qualification standards established by OPM. And that's in our Interior Affairs Manual.
Next slide.
Preference applies to filling vacancies through initial hiring, promotion, lateral transfer, and reassignment. And then preference for RIFs originally was not applicable to reduction in force since such circumstances do not involve the filling of vacancies, which was the whole premise for Indian preference. But after the Mescalero Apache tribe case in 1975, Congress enacted legislation making preference applicable to reductions in force at BIA and also Indian Health Service.
Okay, next slide. When Congress enacted the legislation talking about RIFs, it defined the BIA to mean the BIA and all other organizational units in the Department of Interior directly and primarily related to providing services to Indians. And so that was codified for purposes of that statute. But the part of the Indian preference statute that talks about positions in the Indian office has a much more complicated history. Before we get into that one, we're going to flip to the next slide, and then we'll go back to the Indian Educators Federation case. But I wanted to have Kathy talk a little bit about what Indian preference means today for the BIA. So if you go to the next slide, we'll have some statistics. In 1934, there was only 34% of BIA employees were natives. And today, that statistic is ranging anywhere from 80 to 87% of BIA employees have Indian preference. For the application process, we do require proof of eligibility submitted with the application, and that proof is by membership, descendancy, or degree of Indian blood. And as you all know, we do have to use that form BIA 4432. One thing I think that solicitors are surprised at is that the selecting officials that do the hiring do not get provided a copy of the BIA 4432. So those selecting officials, supervisors, have no idea what the background is for either tribal affiliation, descendancy, or whatever else is, makes their criteria. In the accepted service appointment, if satisfactory performance
the individual is converted to competitive appointment after 3 years of service. And that's unique, and unlike the solicitors who are also in the accepted service, they never reach conversion rights to competitive status.
And if you go back to slide 7, then we're going to talk a little bit about how the term positions in the Indian office have been interpreted over the years. As I said, Congress did define BIA to include all other positions in DOI directly and primarily related to providing services. But in the Indian Educators Federation local case, the DC District Court case in 2008, the union filed a lawsuit against the Secretary of the Interior challenging whether, or asserting that OST and the Assistant Secretary of Indian Affairs offices should be included in Indian preference. They wanted a declaration from the court that Indian office should be interpreted to mean any position in the Department of Interior that directly and primarily relates to providing services to Indians. At that point, the Department of Interior took the position that the definition should be more narrow and that Indian office should be BIA and any subparts that had been moved intact to other parts of the Department of Interior. The judge in that case looked at the term Indian office and determined that it was ambiguous. It is not defined in Section 12 of the IRA, and there is no such office within Interior. So he looked at what Interior's legal determinations had been over the years in trying to define the Indian office. And in 1979, Solicitor Krulitz had been asked whether 2 new offices that had never been a part of the BIA, but which had been created and were now going to be reporting to the Assistant Secretary for Indian Affairs, whether those offices should apply Indian preference. And Solicitor Krulitz determined that the Indian preference should apply to any positions in the department which directly and primarily relate to providing services to Indians. In 1986, Associate Solicitor Tim Elliott had occasion to look at Indian preference in response to the Department of Interior's plan to consolidate administrative services across bureau lines. And he looked at the definition of that had been provided by Congress in the RIF statute 472A amendment, and that it defined BIA as all positions in Interior that directly and primarily relate to providing services to Indians. And he looked at that and thought that's probably the right interpretation, but he said that the more department-wide the duties of the position are, the less likely Indian preference would apply, and whether Indian preference applies should be determined on a case-by-case basis, considering all the facts and circumstances. 2 years later, in 1988, Solicitor Tarr reversed course, and he determined that Indian preference should only apply within BIA, and a lawsuit was filed in 1991. It was appealed to the DC Circuit, and the DC Circuit reversed on other grounds, or did not make a decision on those grounds, but in dicta said that Solicitor Tarr's interpretation was a dramatic break from the past, and that suggested interpretation probably should be examined in a forum with more due process, in other words, some sort of rulemaking. So in 1996, the department proposed rulemaking. They were going to amend 25 CFR section 5.2 to say that Indian preference would apply to the BIA and any units transferred intact within Interior that continued to perform BIA functions. That rulemaking was published, but no rule has ever been adopted to date. So 5.2 has not been amended with that more narrow definition. And after going through that history, the district judge determined that in construing statutes liberally in favor of Indians, that it should be, Indian preference should be applied to all positions in Interior within and without BIA that directly and primarily relate to providing services to Indians. The judge said he thought that was consistent with prior legal determinations and that it was consistent with the legitimate expectations of Indians. During that litigation, the United States was concerned with whether interpreting it that broadly would have constitutional ramifications. In other words, whether there could be some due process implications for racial discrimination. And the court said, so long as Indian preference is applied to assure greater participation by Indians in positions that increase self-government, application of Indian preference will not run afoul of constitutional norms. Therefore, the judge held that positions outside the BIA should be granted Indian preference, assuming they're positions that promote Indian self-governance. That case was appealed to the D.C. Circuit by the plaintiffs, by the union, because the court had not granted it injunctive relief. It had just granted declaratory relief, and that appeal was dismissed, so the court case didn't go any further. But because there was no injunctive relief, enforceability remains an issue, and usually the way that these issues come before boards, tribunals, or whatever are by individuals claiming some sort of discriminatory animus under Title VII or something like that. Okay, if you go to the next slide, we've covered that statistics and accepted appointments. So then the next slide, we're going to talk about why it is important that we look at whether the positions promote Indian self-governance and whether they are, whether Indian preference is applied to ensure greater participation by Indians. And that comes from the United States Supreme Court case of Morton V Mancari, which was decided in 1974. And in that case, the United States Supreme Court determined that preference is an employment criteria, not a racial preference. The case came about because in 1972, BIA had issued a policy letter. It had been approved by the Secretary, and the policy said that Indian preference was going to be applied to promotions as well as vacancies. And the non-Indian employees in the BIA challenged that Indian preference statute, claiming that it was contrary to the newly passed anti-discrimination provisions of the Equal Employment Opportunity Act of 1972. And that act prohibited discrimination in federal employment. Up until that time, there had been executive orders that had prohibited employment discrimination, but they were only executive orders. They did not have the force of law. There was a feeling that a lot of discrimination was going on in federal employment, and the Civil Rights Act of 1964 exempts the federal government, so there wasn't a Title VII issue there. So the non-Indian employees sued. The Ninth Circuit concluded that Indian preference was impliedly repealed by the Equal Employment Opportunity Act and granted injunctive relief in favor of the non-Indian employees. That injunctive relief was stayed by Justice Marshall, and the full Supreme Court then took the case and determined that the Equal Employment Opportunities Act did not, impliedly repeal the Indian Preference Act from the Indian Organization Act. And the court determined that it didn't, also did not constitute invidious racial discrimination in violation of the Fifth Amendment to the Constitution. The court said that the preference was not racial. It's an employment criterion reasonably designed to further the cause of Indian self-government and to make BIA more responsive to the needs of its constituent groups. And the court likened it to participation by the governed in the governing agency, and so they said, like, because senators who are representing their constituents have to be citizens of a state to go to Congress to represent that state, that BIA should be more representative of the communities it is serving. And so they also determined that it was a legitimate, non-racially based goal of self-governance, and talked about the unique status of Indian tribes under federal law and Congress's plenary power, which I'm sure most of you have heard about, and that we have just a lot of federal statutes that single out for special treatment the constituency of tribal Indians living on or near reservations. And the Supreme Court said, if these laws derived from historical relationships and explicitly designed to help only Indians were deemed invidious racial discrimination, an entire title of the United States Code, that being Title 25, would be effectively erased, and the solemn commitment of the government toward Indians would be jeopardized. So how does this Indian preference relate then to Title VII of the 1964 Civil Rights Act? Next slide. Actually, the Title VII has defines employer as not including either the United States or Indian tribes, but it also has exempts Indian preference from Title VII. So the next slide, we have what is that? So we know that Indian preference doesn't necessarily is not unconstitutional or does not necessarily implicate invidious racial discrimination. But we do know from that the Title VII doesn't allow discrimination based on tribal affiliation. And in the Dawa Vendua case, the plaintiff, a Hopi Indian, alleged that because he was Hopi and not Navajo, he was not considered for a position with the power district, which was a municipal power district under Arizona state law. It was operating a generating plant on the Hopi reservation, and under a lease with the on the Navajo reservation, and under a lease with the Navajos, it was supposed to hire Navajos first, who lived on the reservation, then Navajos who lived off the reservation, and only if they could find no other qualified individuals, they could hire non-Navajos. So the plaintiff sued under Title VII because the power district was considered an employer under that title. And the defendant alleged that they were exempted by tribal preference policies and also by Indian preference, and they filed a motion to dismiss, which was granted by the district court. The Ninth Circuit reversed, saying that the discrimination in employment on the basis of membership in a particular tribe constitutes national origin discrimination. And although the United States was not a party in this lawsuit, the Supreme Court on petition for cert did ask for the Solicitor General's opinion, and the Solicitor General filed a brief saying that it supported the Ninth Circuit's decision that it was discriminatory. So on the next slide, we see what is national origin discrimination. It is defined by the EEOC as including but not limited to the denial of equal employment opportunity because of an individual's or his or her ancestor's place of origin, or because an individual has the physical, cultural, or linguistic characteristics of a national origin group. And we're going to turn to the next slide, and then I'm going to turn over control to Anna Rowe, and she's going to take you through some recent EEO issues and cases.
Afternoon, everybody. Can you hear me okay? Well, I guess you're on mute, so I'll assume that you can unless somebody speaks up. This slide is slide 13, Native American EEO issues. Karen already talked about the Wavendua case that pretty much established the notion that tribal affiliation is a valid issue under Title VII and can proceed as a complaint. And so I've just listed here a couple of recent cases. This first one came out of the Southwest Regional Office of the BIA just back in June, and there the complainant was alleging that the Southwest Regional Office essentially drove him out because they wanted a Pueblo member in the position that he was in. His case failed. The second one that's listed there is a case in the Northwest region that is now in district court in Idaho, and it's in progress, but it's just another example of a tribal affiliation claim. These tend to come up when you've got an employee of one tribe, of a different tribe from whatever the local tribe is. I've seen this in a few different settlements that I've handled since being here these past 2 years, and it seems to be a fairly common Native American issue that comes up in the EEO context. Going to the next slide, skin color. This is not one that I've yet encountered, but from talking to Karen and Kathy, skin color has been alleged in cases that they have been involved in, and Title VII prohibits employment discrimination because of color, which includes lightness, darkness, or other color characteristics of the person. So just as you may be familiar with African-American type cases with different skin colors, the same holds true on Native American issues and has been an accepted ground for complaint. Going to the next slide, there's a question of whether or not tribal employees should have access, do have access to the agency's EEO process. And you'll see this last case that cited Smith v. Babbitt. That came out of the Warm Springs tribe, and the individual there was a tribal employee, but her second level supervisor was a BIA employee, actually in the chain of command. And so that case, she was found to be allowed to have access to the agency's EEOC process using the common law agency test that's described in Ma versus Department of Health and Human Services up above. And that case, Smith v. Babbitt, was relied upon by the Office of Civil Rights back in 2006 to accept another case that came out of the Warm Springs, a tribal employee of Warm Springs out here, and that was the Sumpty case that was recently dismissed because the complainant stopped prosecuting it. But that is still an issue for some places, depending on how their supervision is set up, related to BIA versus the tribes when they're tribal employees. You see, however, there are other cases above there, Monette and Covington, where the division between the tribes and the BIA was clearer, and there was found to be no access to the agency EEOC process for those individuals. Going to slide 16, the BIA driving policy. It's my understanding that the driving policy is being revised, and I believe it's currently with general law awaiting its final revisions, and we're all in the field, at least speaking for myself, we're anxiously awaiting the revised policy so that we can go forward with these new issues with the driving policy. And as you'll see, it's been ongoing and it's been tested in a couple of different forums. First, just to explain a little bit about the driving policy for anyone who's not familiar with it, it hinges on May 3rd, 2006, that motor vehicle operation policy. And there have been a few clarifying memos since then, but that's the main language. And under Section 2, it describes the driver qualifications, and one of them is that the employee cannot have any convictions or uncontested citations within the 3 years immediately before they submit their application form. They have to apply each year for a motor vehicle operator's license, and so in the 3 years preceding it, they can't have conviction or uncontested citation for reckless driving, DWI, DUI, or leaving the scene of an accident. The second qualification that sometimes comes into issue is that the employee cannot have demonstrated a pattern of unsafe driving or behavior, particularly involving drug or alcohol abuse. And this is considered a fairly stringent policy, and it came into effect after a horrific accident. I think, trying to remember, I don't remember the year, but a BIA employee was driving under the influence in a government vehicle and caused an accident which killed 4 people, which resulted in this policy. Going to the next slide, you see Section 3B6, which is roles and responsibilities. And under that section, a supervisor is responsible for immediately terminating the driving privileges for anyone who is arrested for, charged with, or convicted of reckless driving, DWI, or DUI. To give you an idea of the scope of the impact of the policy, in 2012, there were 6 employees affected, which resulted in 1 removal, 2 retirements, 2 resignations, and 1 change to lower grade. And in 2013, there were 19 employees affected, resulting in 5 removals, 2 terminations during probationary period, 6 modifications of position descriptions, 2 resignations, 3 reassignments or change to lower grade, and then 1 had his or her conviction overturned, which presumably resulted in the termination of driving privileges being overturned as well. So cases that have challenged the driving policy, so far we have decisions out of the Merit Systems Protection Board and the FLRA, and they conflict. The MSPB was simply looking at whether the employee had lost a condition of employment when he lost his motor vehicle operator's card as a result of the policy, and MSPB upheld that removal. The FLRA was reviewing an arbitration decision in the Shavehead case. Similar scenario, the employee lost his driving privileges and was removed after arrest for DUI. But in that case, the arbitrator ordered the employee reinstated and directed the agency to cease and desist implementation of Part 3B6 of the May 3rd, 2006 Agency Motor Vehicle Operation Policy. And you'll see the rationale on the next slide. And he did that because he found that the policy had a disparate impact on Native Americans, and that because it was in violation of Equal Employment Opportunity Law, it was also in violation of the collective bargaining agreement. His rationale for finding disparate impact, the policy applies only to BIA employees. At the time, 88.5% of those were Native Americans or Alaska Natives. The arbitrator found that the policies of the 8 other subordinate DOI agencies required a conviction or an on-duty arrest, whereas BIA's policy required immediate termination of driving privileges for anyone arrested for a DUI. And then, the final summary finding was the BIA policy applies to 71.7% of all American Indians employed by DOI, but to only 1% of all non-Indians employed by DOI. The agency filed exceptions based on the arbitrator's invalidation of the policy, but FLRA found that it lacked jurisdiction and declined to review it. The agency, sorry, I switched slides on you. The agency didn't implement that portion of the arbitrator's decision. And so the policy has continued, but as I said before, it's undergoing revisions right now. We do not yet have any EEOC decisions on the driving policy, but there are at least 2 formal complaints currently pending which allege disparate impact. I have a case here that also challenges the driving policy, but surprisingly enough, they have not made the disparate impact argument thus far. That one's being challenged on gender grounds. On the next slide, just some final statistics on the types of cases that Office of Civil Rights for BIA has seen, and this is in the last reporting period. They had 7 cases alleging tribal affiliation, discrimination, 2 cases alleging discrimination based on skin color, and then 8 cases that were either Native versus white or vice versa. So there are a variety of EEO issues that center around Native American identity. That is the conclusion of our information portion, but we wanted to leave time for questions for anyone who wants to chime in with those.
This is Venus, Prince. I was just wondering, have you seen any cases or has anyone started challenging the policy because of someone might not be a member of a federally recognized tribe, given that it's sort of Morton is sort of the basis and justification for the preference policy? Has anyone challenged that a person of sort of tribal descent or state recognized tribe shouldn't be able to sort of use it?
I don't know that they've been accepted. Here in Montana, there is a tribe that has been fighting for recognition, the Little Shell tribe, but the law is pretty clear that it must be recognized and indigenous. And one of the reasons that the Little Shells have not been able to gain their recognition is because they were originally in Canada before coming over, after the treaty was offered to them. But I don't know, without talking to EEO, if they've ever had that type of class accepted for review.
Yeah, I was just curious if any cases that you guys have seen sort of raised that issue.
There's another reservation in Montana, the Blackfeet tribe, which has a sister reservation that extends into Canada, the Pagan or the Blood tribe. And they've also tried to apply for federal jobs, but of course they can't get a 4432 form signed, which that form has to be directly signed by the tribe to show the enrollment information. And if the tribe doesn't have good records or doesn't have that authority within their constitution, then of course the form is signed by the BIA official. But I don't know of any other instances where there would be a non-recognized tribe. But I wanted to just comment on that Shavehead FLRA ruling. One of the things that was complicated about that case was that Mr. Shavehead received a 5-year deferred prosecution in the state of Idaho. I mean, for a DUI, that is just unheard of. When we have deferred prosecution cases for DUI, DWI, whatever, we will try to accommodate. If the deferred prosecution is a year, we'll try to find work for that individual to do until the prosecution is completed. You know, they've met the terms of their agreement. But to us to accommodate an irrigation ditch rider for 5 years was very burdensome for the agency. And then for the arbitrator to say we had to cease and desist on our policy, clearly he extended his authority there.
This is Anna. Here in Washington State, deferred prosecution it's only for a year, but it requires the individual to admit that they've committed the offense for which they were charged. And so we've treated those largely as uncontested citations. which under the policy, you can't have had one of those in the previous 3 years. And so we have been moving forward with removals on that basis.
Are there any other questions or comments?
This is Rob Hall. I had a question about why the Peabody litigation is not included in this discussion with EEOC, since that specifically addressed the inclusion of a tribal preference requirement within the coal leases, and we've put a lot of energy on the litigation side, at least, in trying to make our argument with the EEOC when they found that tribal preference was not allowed and was in violation of Title VII.
And I think, this is Karen, and I think the only distinction just in in terms of limitation, time limitations, the case that we were dealing with was Indian preference, and the court did make the distinction that in that case the defendant had spent a lot of time saying that that the Indian preference was okay, and not so much the tribal preference or the taro or the lease with the Navajo, and it was more the facts of the case and how it came to the court, and why the court looked at the Indian preference part of it, but not necessarily the taro ordinances.
And our focus here was really on employees within the Bureau of Indian Affairs.
Okay.
That would be the other reason. But if you have stuff you would like to present on that, I'd love to hear it.
Well, it was just more, we've had a number of data calls, and one of the responses we've had by Bureau of Indian Affairs in particular, but other agencies that are contracting or working with tribes on contracts, is to include tribal preference. And we see it now. We have it in other leases that have come up and mineral agreements where there's an express tribal preference in the lease that we approve. So it's a federally approved lease that includes a tribal preference in addition to Indian preference.
Right, and tribal preference, we do have that issue, and we just, I chose not to cover it here.
Okay.
Just because it's just...
No, and that's fair. I was just curious how it...
Yeah. And that was an interesting thing about that case that I thought was that because the defendant had really hung its hat on on Indian preference and not on the tribal preference, the taro stuff, the court didn't feel obligated to examine it.
In the case that you've cited?
Yeah.
Right, yeah.
Yeah, I know it can get even trickier because with the taro preference, I know a lot of tribes, I don't know if you guys are seeing it out there, a lot of tribes are not just having tribal preference, but sort of having descendant preference, spousal preference, and some other things incorporated into taro ordinances.
I haven't seen that yet, but that's something to look forward to.
Oh, yeah. It'll make things even more interesting.
Full employment for the attorneys. We always like that.
That's right.
Any other questions or observations? Kathy, did you have anything?
No, but I am Native. My dad is enrolled member of the Chippewa tribe in North Dakota, and my mother is Danish. So I am of the light skin. Any criterion under Title VII I could probably file. So if you have any questions, just, on a personal basis, I'd welcome them.
And we do have our contact information on the last slide if you have any questions for us or anything you want to talk about offline.
You did bring up tone, skin tone and color, and that is something we've had at least 3 cases to my knowledge out here where the grievance claims were specifically on discrimination based on tone. And one, I believe, was resolved through settlement. One, and perhaps the other were both denied as a basis of discrimination in their particular instances. and it works both ways. Sometimes it's a lighter skinned person who's claiming discrimination by a supervisor who is darker skinned.
Yeah, and just on a personal note, I actually did file many years ago. Karen and I have been working in the same region for 25 years, but I did file more than 20 years ago on a supervisor who was dark-skinned, and in a all-staff meeting, she made mention that she didn't think Chippewas should be enrolled because they're not, like, full-blood. Mm-hmm. And I didn't file to get compensation or to embarrass her or anything else. I just thought such comments needed to stop in the workplace, you know, that they were offensive, whether I was Chippewa or you know, a toad. So, yeah, you're right. It does go both ways.
And Kathy and I had a case years ago, and this was the first time I had seen it, where we had within an agency, and it was the same tribal affiliation, Crow, but the claim was discrimination against dark-skinned, full-blood Crow by lighter-skinned, perhaps not full-blood Crow.
Yep.
And ironically, in the grievance process, and just kind of digressing from the EEO, just in the grievance process, there is more contention between natives versus non-natives, which is surprising to me. You think as a native organization, we would try to assist each other and better each other, but you just don't see that. You just see, like, if I'm Navajo and there's a Hopi trying to be my supervisor, you know, I'm going to tear him down. I just don't get that mindset. But at last count, there was like 563 different recognized tribal entities. I service the state of California, and 5 years ago when I was servicing them, I think there was 104 different recognized band, and today there's 107. So things change. It's just too many different varieties to keep control of. And the other thing is, when you guys were talking about the TARO offices, it's really hard for the federal government to just ignore the TARO office, especially at an agency where they're trying to get employment for firefighting crews or road construction, where they're actually sitting down with individuals who have a hard time completing applications, and then to say at the end of the day, oh, by the way, we can't just hire individuals from your tribe. We can't ignore preference from all entities. Just my opinion.
There's something, and this might be a helpful time to bring it up with this group, is we also have questions arise when it's a federal project, oftentimes by another department. Corps of Engineers comes up every once in a while, but projects where they are conducting or constructing, rather, some kind of facility or structure in Indian country. It may be on the reservation, it may be in allotted areas outside of the reservation, formal reservation boundary, and the tribal labor office, the case of Navajo, for example, or TIRO office, will attempt to impose tribal preference requirements on the federal contractor. And I'm curious how that's handled in other regions, or if you've seen cases, how it's been handled under the case law. And these are all contracts that are being let through the FAR process, not through ISDA.
And this is Karen. I haven't had any experience in that for a long time. I mean, I remember that when I first came across that issue, it was when they were building the interstate through the Crow Reservation, and whether the Federal Highway Administration had to have TARO, you know, give tribal preference. And I think they agreed to do it, but I don't know enough about and don't remember enough about it to.
Yeah, and actually not through Interior, but HHS, Indian Health Service, was building a hospital, and TARO at the same thing. They wanted their Masons to only be tribal members or be in violation of the contract, and I think an injunction was filed to stop work until they got that resolved. I'm sure it's going to come up, but how it's remedied, I don't know.
Okay. Yeah, it's interesting. We're seeing it increase. And like Karen was saying, I think oftentimes the federal agency at least will just agree to include it as a way of making sure the project gets completed. But it's a real problem.
As I recall, that was the last stretch of the interstate that was completed in Montana.
Mm-hmm.
You know, Anna brought up a good point about the tribal employee perhaps getting rights to EEO because she had a BIA supervisor. And I think I need to make sure that when managers are doing those memorandums of agreement to oversee tribal employees, they need to make sure that all of those issues are covered, whether it be how they file a claim of discrimination, hostile work, even workers' comp. I think all that needs to be addressed clearly, because that was surprising to me.
Yes.
Well, we're reaching the top of the hour. Anything else anyone wants to ask about or comment on? If not, well, we thank you very much for tuning in, and we hope you enjoyed the presentation.
This is Pat Reedy. Thanks so much. This is really interesting, very helpful. Appreciate it.
Pat, do you have to go?
Thank you guys very much.
Aaron, Kathy, and Anna, thank you so much for your time and efforts. We really, truly appreciate it. And sorry for all the technical difficulties we had, but thank God you got it up, Anna, and I really appreciate it.
Thank you.
Bye.
Bye-bye.
Bye.
Bye.